Welcome to Commercial Collections Corner, Episode 7. My name is Christopher Nolan, and before you ask, no, I did not direct Batman or the Odyssey. I am a senior commercial collections attorney here at Weltman. I've been an attorney since 2013, so just over 13 years. The reason I wanted to do a webinar on service is because currently a good portion of our time here at Weltman is spent reviewing service affidavits and trying to determine whether a defendant or a commercial entity has been properly served, and if they haven't, determining the next best course of action and steps to take. It's my hope that this webinar can shed a bit more light on the topic for other people. This presentation is meant to be educational. It's not legal advice, and it's not a substitute for checking the current statutes, Supreme Court rules, local court procedures, or case law when applicable. Service rules can be technical, and small factual differences can matter a great deal. By the end of the presentation, you should be able to answer 4 core questions. First, who is authorized to serve process? Second, how do we properly serve a defendant, an individual defendant? Third, how do we properly serve a private corporation or business entity? And fourth, what do we do when standard service isn't working? So before we get into it, you can type questions into the questions feature to be answered during the presentation. This webinar is being recorded, and a link to the webinar will be sent to you following the presentation. Also, at the conclusion of today's event, a brief survey is going to appear on the screen. Please share your feedback, any advice, tips, or any future topics you'd like to see in the future. We'd welcome those to be sent to us. We plan to conclude the session before 12 p.m. Eastern, 11 a.m. Central, but we'll probably be done after about 45 minutes. So let's get started. Our agenda will follow the complaint, summons, and placement for service. Part 2 will discuss methods for serving individuals. Part 3 is going to discuss service on corporations, private entities, LLCs, and defunct commercial entities. And Part 4, we are going to address just a few common issues that are encountered when serving individuals and businesses. We'll also try to talk about practical solutions and maybe run through a hypothetical for process servers, and discuss how keeping proper notes and filing detailed service affidavits can turn even a failed service affidavit into an order for special service permitted by the court. So first, we're going to talk about complaints and summons. I should mention, I don't want to spend a lot of time on this, but I should mention that the amount and type of relief you're requesting in your complaint can have an effect on the type of summons that you're going to issue. And also, as we go through, when I refer to a summons, I'm referring to the summons with the complaint attached. So a lot of times these statutes and things we're discussing will refer to simply the summons, but after the summons has been issued by the court and it's going out for service, we're talking about the summons with the complaint attached to it. So when you're serving a defendant or a business entity, it's not just the summons, it's the summons and the complaint. So let's get started. In Illinois, as in most other states across our country, a civil action begins with the filing of a complaint. After that, the clerk issues the summons upon request. The summons is a formal command that tells the defendant that there's a lawsuit filed against them. It identifies the court and what the defendant is supposed to do next. If there are multiple defendants, multiple locations, or services expected in more than one county or location, duplicate original summonses may be issued or requested to be issued. Issuing duplicate summons, it can be useful when more than one person or entity needs to be served at the same time, or when service may need to be attempted in different locations simultaneously. It's also useful to know that Illinois law provides that a court's jurisdiction is not affected by a technical error in the format of the summons if 3 things are true. First, the summons was issued by the clerk. The person or entity to be served is identified as a defendant on the summons, and the summons is properly served. So that rule is important but it doesn't excuse errors like serving the wrong person, skipping or forgetting to complete a required mailing, using an unauthorized server, or filing an unreliable affidavit of service. It's just a safety provision for technical format errors. It's not a license to ignore service rules. So as we see here, that section 2-201 says filing a complaint commences the action. And like I said, I don't want to spend a lot of time on complaints and the technical aspects of summons, but we just need to mention them before we get into service. But just to touch briefly on the complaint, the caption of your complaint should properly identify the legal person or entity against whom you're seeking a judgment. For an individual, you're going to want to include an individual's full and complete name if you know it, and any known aliases if applicable. So AKA sometimes referred to. Sometimes you'll see that in complaints. You'll want to include those additional names if they have those. Also, you're going to want to check spellings of names. That can be important. Sometimes people spell their names a bit differently, and I would know. I spell my name without an H. So also for businesses, when we discuss businesses, you're going to want to determine the trade name, whether that belongs either to a sole proprietor, a partnership, a corporation, an LLC, or another type of entity, such as a not-for-profit, because methods of service can differ as to each type of entity. So let's talk about the summons just briefly. This can be a little dense, so I apologize, but when issuing a summons, you're going to want to select the proper Rule 101 form. Rule 101B1 states that an action for money not exceeding $50,000 exclusive of interest and costs, or an action subject to mandatory arbitration where a local rule prescribes a date, it uses a summons with a specified appearance day of 40 to 61 days after issuance. 101B2 covers eviction and recovery of tangible personal property. If service will occur outside the state under section 2-208, and we're going to get to that. Rule 101B3 sets a return day of 40 to 60 days after issuance, and it bars default until 30 days after service. And Rule 101D covers all the other cases and requires an appearance or answer within 30 days after service. So some of those are cases where you won't have a specified date. You'll issue the summons, and the summons will inform a defendant that they need to respond with an answer, an appearance and answer within 30 days. If after the expiration of that time, the person hasn't filed an appearance or answer, it's incumbent upon the attorney to motion the case up, file a motion for default. So you won't have a specified date where you need to return to the court unless you request it. And as indicated previously, use of the wrong form of the summons will not affect the jurisdiction of the court if those three things are true: that it was issued by the clerk, the person or entity being served is identified as a defendant on the summons, and the summons was properly served. So again, check the spellings of the names in your complaint caption, make sure you include aliases, and make sure you follow the rules that we are about to review. Placement for service. Supreme Court Rule 102 in the state of Illinois discusses some of the date requirements for service. Section B indicates when a summons must be issued for service, as well as the requirements for serving the initial summons. Under Section D of Rule 101, which requires a defendant to file an appearance within 30 days, which we just discussed, Rule 102 gives the plaintiff 30 days after issuance of the summons from the clerk for the summons to have it served. So once you request a summons under that, under Rule D, you're going to want to have that placed as soon as possible. Under Rule B1 of Rule 101, which refers to a summons with a return date, that summons may not be served later than 21 days before the scheduled date for the appearance. Under Rule B2 and B3 of Rule 101, that summons may not be served later than 3 days before the date of the appearance. And just keep in mind that if you are serving an out-of-state defendant, just because you meet the deadline of serving at least 3 days prior to a scheduled appearance, you will need to wait at least 30 days after service before requesting a default from the court. So, and finally, the person serving the summons should endorse the date of service on the copy left with the defendant. So before we get into the specifics of the service statutes, let's just talk briefly about people who are authorized to serve process. Up until 2025, Illinois separated Cook County, which, for those that don't know, Cook County is where Chicago is located. It's our most populous city in the state, obviously. It separated Cook County from the rest of the state by requiring process in Cook County to be first attempted by the sheriff's office before employing a private process server, but that is no longer the case. Now, service may be placed with a private process server in Cook County and throughout the state without requesting a special appointment by the court, as long as the person serving process is licensed or registered as a private detective under Illinois law. There are other professions that may be able to serve process. So you'll see under this statute, we don't typically use private alarm, private security, fingerprint vendors, or locksmiths to serve. We typically use the registered private detectives. You can still use the sheriff for service, and who to use for service in a specific situation is basically for the attorney to determine based on all the facts and information you have in your case. So you may also file a motion with the court to request process be served by a private person over the age of 18 who is not a party to the action. Personally, I've never used this option myself, but it's probably worth keeping in your back pocket for special circumstances. Let's say you're trying to serve someone who you know will be in a certain location at a certain time, and you know another person who's over the age of 18 who will also be in that location, perhaps. In that situation, you might want to file a motion with the court requesting that this person be allowed to serve process in this specific circumstance. So let's talk about service on individual defendants. So 735 ILCS 5/2-203 sets out the basic requirements for service upon individuals. Service on an actual defendant is usually preferred, but the statute provides that a process server may also serve a family member or person residing at the defendant's abode or home, as long as they are at least 13 years of age or older. The process server informs that person of the contents of the summons, and then the process server follows up by mailing a copy of the summons in a sealed envelope with postage fully prepaid, addressed to the defendant at his or her place of abode. This is sometimes referred to as substitute service or abode service when service documents are left with a member of the defendant's household. Keep in mind that substitute or abode service is not complete without following up by mailing the summons to the defendant at the address served. So you're basically trying twice. You're going to give it to a family member of the household, someone who resides with the defendant, and you're going to follow up with that mailing. And your affidavit needs to also state that you followed up with the mailing. Abode service also requires some conversation with the person accepting service. Best practices here are to get a full name, confirming their relation to the targeted defendant, and confirming that the person accepting service lives at the location being served. So if someone is trying to serve a defendant at their home and say, this gentleman here just indicates that he's a babysitter and he's only there, that's not a proper target, because it doesn't sound like that person would be living at that location. It just might be someone who's there for a short time. So that would not be an appropriate target for service. So you just need to engage in a bit of conversation if you're a process server, trying to get a little more information from who you're trying to serve. So continuing, Section A of 2-203 discusses service on gated communities or condos and apartment buildings that prevent public access to someone's residence. And I'm going to talk about this a little bit more when we talk about common issues, because this can be an issue with serving defendants. But just Section B of 2-203 discusses the return service affidavit and the information that the court wants to see. And this is important. When serving via personal or substitute service with a member of the defendant's household, it's not enough to simply say that the summons and complaint were left with a member of the defendant's household over the age of 13. It must state whether the summons was left with a man or woman. It should note the race and approximate age of the person who it was left with, and you need to note any conversations you had with that person. You don't need to be a carnival worker. You don't need to be an expert at guessing ages. You just need to have a rough estimate of the person you spoke to. You might want to note hair color, the height, weight, things like that, that would perhaps, if it came to it, be able to properly identify the person that you placed substitute service with. The affidavit of service should also note the specific location, including the exact address, the date, the time of day when summons was left. It should also note, as completely as possible, any conversations had with anyone answering the door, discussions with neighbors, doormen, people that are controlling access to the home. You'll want to note those conversations as completely as possible. We don't see it here, but Section C notes that providing a false affidavit to the court regarding service may result in liability for civil contempt. So it's important that the affidavit stick to facts and that the process server take good notes regarding observations made, conversations had, and any additional facts supporting service should be included in the affidavit. In order to kind of demonstrate this, I created a quick activity we can kind of complete together. So let's take a look here. Let's say we're serving a John Smith because we have information showing that he lives at the address shown here. For our purposes, let's just say it's 123 Fake Street in Illinois. But before we even knock on the door, we're verifying that the address on the house matches the address we're attempting to serve. We're not just relying on Google Maps to show us where we should be. We're confirming. I've blacked out the address on this house, but you're going to want to confirm that it's the proper address. So let's say this is the first time we're trying to serve this location, and it's, let's say, a Tuesday at 10 a.m. So for the first attempt, we go to the door, we ring twice, we knock, and we receive no answer. We hear a dog barking from inside the house. What should be noted about this attempt? First of all, we should note there nobody answered the door. The server noticed that a dog was barking from inside the house. We also want to note the presence of any cameras, like the doorbell camera seen here. It's a Ring camera. But why do we want to do that? If a defendant has the capability to screen you at the front door, that's important information for a judge to see. What is the presence of a dog barking? Why do we need to include that? Well, the presence of a dog barking informs me, at least if I'm doing, logical, using my deductive reasoning skills, shows me that someone probably lives here at this location. So it's not just a no contact, it's, someone lives here, perhaps, just giving them benefit of the doubt. Most people walk dogs, they take them outside. So maybe they're just not home at this moment. So I would conclude that someone definitively lives here and that a future attempt at a different time may yield different results. So let's try a different time. So let's say we come back a week later at 3 p.m. rather than 10 a.m. And it's a different day of the week on a Wednesday. We ring twice, we knock again, we receive no answer. Again, the dog barks when we knock, but nobody answers or responds to the Ring doorbell. But what do we see when we pulled up? When we look around, we notice that there's a white Jeep parked out in front of the house. So what are we going to note in our results? It's pretty easy. We're going to note the presence of the dog and the white Jeep, as well as the license plates of that vehicle. We do this because Skip tracing can inform us of property and car registration. So even if a defendant doesn't answer the door, if there's a car that's in and out of the driveway or parked out in front of the house, and we can determine that that vehicle is owned by a defendant, that's really good evidence for a judge to grant a motion for service via alternative means. So we want to note as much as we can. We want to note the vehicle. Let's say we come back on Thursday. So we had no luck at 10 a.m. and 3 p.m. and now we want to try in an early morning attempt. On the third attempt, we go by. Before we approach the door, we notice that here the garage door is open and we see a car in the garage. It's a different car. It's not a white Jeep. So if we again receive no response to our attempt to ring the doorbell, knock, we're going to note that the garage door was open, that there was a black sedan inside the garage, and we're going to note the license plate. We're not entering garages. We're not opening mailboxes. We're simply looking around and being observant as we attempt service at that location. So let's try one more time. Let's say on a fourth attempt, we go by the house at 5:45. So we had no luck at early morning, in the afternoon. So we're going to try in the evening. You might even want to try later. You might even want to try a weekend day. This time, let's say the garage door is closed, but as we approach the door, we notice some packages at the front door with the defendant's name on them. So it looks like we have some Amazon packages here. So if we have the same result, no contact, and we're ready to file our affidavit, what should we note? At this point, many process servers will note that they will file a service affidavit noting the 4 attempts and stating that service failed due to no contact, but that final result isn't the entire story. If we've been noting the cars in the street, the car in the garage, the presence of the dog, the ring doorbell, the packages on the front doorstep, I don't really have any doubt as an attorney that I could make a really good argument and submit to the court a motion that basically requests service via alternative means. And if the judge tries to check whether or not we diligently tried to attempt service, I don't think that there will be any problem showing the judge that we have reason to believe that this defendant lives at this location and has not been responsive to our attempts to contact them. So what's the most important part of this? Field notes. So not every service attempt is going to end with the placing of the summons and complaint in the hands of the intended defendant. Going back to our example where we had no contact, but we noted different vehicles in front of the house, vehicles in the garage, packages at the front door. We noted the ring doorbell. That would allow someone to, and just so we're clear, a ring doorbell, that's good information because that allows someone to possibly, if they're trying to avoid service, it allows them to avoid that knock at the door if they choose to do so. So all this kind of information needs to be included in a failed service affidavit that showing that our service attempts, that we were diligent in trying to serve the defendant, but that service is potentially being avoided. Remember that all these facts tend to point in that direction, even details that may seem to be minor to a process server. Those minor details can be what convinces the judge that service is being avoided. It's also worth keeping in mind that these failed service affidavits aren't going to the judges on their own. In our motions for special service or alternative service that we file here at Weltman, our firm typically attaches redacted copies of skip traces that will show, let's say using our example, that the defendant owns the white Jeep or owns that black sedan with the license plate that matches the failed service affidavit. We'll attach that to the back of our motion so the judge can see exactly why we are convinced that the defendant still lives there. When you have a vehicle parked out in front of a house and you can check the registration, those skip traces that check registrations of vehicles, those will show when the vehicle is registered. So Maybe it's not just still sitting there from when they moved. It's been there. If they just registered it in the last 30 or 60 days and it's registered for the next year to that address, that's really good information that shows that that defendant is still at least using that location as their residence. And following up, because this is kind of where we're headed with a lot of these failed service affidavits, it's important to talk about 735 ILCS 5-203.1 and motions for service by special order of the court. Sometimes we call them service by alternative means or motions for special service. And the reason we've been talking about field notes so much and what should be documented, showing reasonable diligence, whether you're trying to accomplish service by posting a copy of the summons and complaint at the defendant's home address, or serving by publication, or serving electronically based on recent changes to Illinois Supreme Court rules, judges are determining diligence through the actions of the process servers and supporting documentation attorneys provide in their 203.1 motions. So whether that is confirmation of an active address, home ownership information, vehicle titles and registrations, it's the server's affidavit taken in conjunction with the supporting documentation is how we are going to show that service was diligently attempted. And despite its failure, we have reason to believe that the defendant lives at that location. So while we're talking about the 203.1 motions for special service, it's worth mentioning some relatively recent changes in Illinois law included in Supreme Court Rule 102F, which allows for service via electronic means using email, social media, or text message. However, I would just note that right now, that is a bit of a tough hill to climb in a lot of situations, because 102F states that if the court is satisfied that the defendant or respondent has access to and the ability to use the necessary technology, so it's kind of prefacing what it wants to see, that it has the necessary technology to receive and read the summons and documents electronically, the following alternative methods of service or combination of methods of service may be ordered by the court when granting a motion brought pursuant to 203.1. So the first alternative method of service we're going to discuss is by social media, sliding into someone's DMs, so to speak. Service by social media can be made by sending a direct message to the defendant on social media platform on which the defendant has an active profile, attaching a copy of the summons, complaint petition, and any other required documents to the direct message, and stating in the body of the direct message, important information, you have been sued. Read all of the documents attached to this message. To participate in the case, you must follow the instructions listed in the attached summons. If you do not, the court may decide the case without hearing from you, and you could lose the case. I'm not going to repeat that for these additional types of service, but because they're all fairly similar, especially when we kind of look at service by email. Service by email should be made by sending an email to the defendant at his or her current email address, attaching a copy of the summons, complaint petition, and any other required documents to the email, and stating in the subject line of the email, important information, you have been sued, and then you put the rest of that information in the body of the email. So this is how we can possibly serve via email. We also have the option now of serving by text message. Text message shall be made by sending a text message to the defendant respondent's cellular telephone number, attaching a copy of the summons, complaint petition, and any other required documents to the text message, and stating in the body of the text message that important information, you have been sued. In addition to the affidavit requirements of 203.1 of the Illinois Code of Civil Procedure, a movement requesting service by text message, email, or social media shall include in the supporting affidavit the reasons the movement believes the defendant has recently sent and received transmissions from a specific email address, telephone number, or the defendant maintains an active social media account on the specific platform utilized for service. And then following up, if you are able to serve via these electronic means, you are required to, within 10 days, file notice by special order of the court. Plaintiff petitioner shall send a copy of the summons, complaint petition, any other required documents by mail to the last known residence of the defendant. So despite seemingly advancing the capability of plaintiff's attorneys to serve via electronic means, there are so many requirements placed on serving via electronic means that it can become a bit cumbersome to attempt service in this way, especially when it comes to completing the affidavit. So 102F2 states that in addition to the affidavit requirements of 203(1) of the Illinois Code of Civil Procedure, a movement requesting service by text message, email, or social media shall include in the supporting affidavit the reasons the movement believes the defendant has recently sent and received transmissions from a specific email address or telephone number, or why the defendant, why the plaintiff or petitioner would believe that the defendant maintains an active social media account on the specific platform requested for service. Also, Section 3 states that the plaintiff shall send a copy of the summons to the last known address. So while a 203(1) motion for service via email, text message, or social media is possible, it shouldn't really be viewed as a sole method for service. You're going to need to start with traditional service, take copious notes about diligent efforts to locate and serve the defendant via those traditional means, and you're going to need to show a judge somehow that the defendant regularly communicates via the chosen method, that they have used that method recently, and that they're capable of receiving this information electronically. To wrap up this topic a bit, as attorneys, we need our clients to provide this kind of information required to serve the electronic means. If that means providing DocuSign audit trails or copies of communications from the client to the defendant, clients need to be prepared if there is going to be problems with traditional forms of service, if it's either an old matter or something that has been lingering for a while. You're going to want to provide as much information as you can about the most recent whereabouts and modes of communication that the client has had with the defendant. So just be prepared to provide that information to your attorney if you are looking to serve someone in this manner. So let's now talk a little bit about service on private companies, corporations. A private corporation may be served by leaving a copy of the process with a registered agent or any officer or agent of the corporation found anywhere in the state, or in any other manner now or hereafter permitted by law. A private corporation may also be notified by publication in mail in like manner and with like effect as individuals. Service on commercial or business entities, it seems fairly cut and dry and simple, and it is, so long as you know what the statute says and exactly what judges are looking for. A registered agent of a business can be found, this is a page that I grabbed from the Illinois Secretary of State website. And on the Illinois Secretary of State website, you can find out whether a business is still active, who the registered agent is for accepting services, the most current address that's been filed with the Illinois Secretary of State, as well as any additional officers that may also be able to accept service. And I've kind of put an arrow where you're going to find that on the page. This is the location where you're going to find the registered agent information. And then you're going to want to click this link here, which will show you any officers and their address that they filed with the Illinois Secretary of State when filing as an officer of the company. I kind of protected the identity of this business just to show you where that information may be found. But this is where you're going to find who is authorized to accept service on behalf of a business. So again, let's talk about field notes. When serving a business, whether it's a retail store, a business office, a restaurant, or anything in between, process servers will often be greeted by, let's say, a store manager, a secretary, an administrative assistant, or some other similar type of front-facing position at the business. It's important to remember when we go back to that statute that only the registered agent or an officer of the company is authorized to accept service on behalf of the business entity. Even if someone presents as having authority over the business at a specific time, that doesn't necessarily mean that that person meets the requirements of having authority to accept service on behalf of the business. So if it's a small business and there's one person in the store, they can identify themselves as the current manager on duty, so to speak. That doesn't necessarily mean that they are able to accept service, and process servers need to be aware of the statute and what it says. And if a registered agent or officer can't be found at the location indicated by the Secretary of State records, the process server should take proper notes indicating who he or she spoke to at the business, including a first and last name, their title, and anything they said regarding the availability of the registered agent or another officer. If they indicate that the registered agent doesn't work at that location, or something like, they're never in, I never see them, we would want that information to be included in a failed service affidavit so that we can request service via the Secretary of State. And that's where we're going to talk about this statute. 805 ILCS 5/5.25. This allows service of process on businesses through the Illinois Secretary of State when the corporation fails to maintain a registered agent in the state, or when the registered agent cannot be found after reasonable diligence trying to serve the registered agent at the registered office in the state. So that address we saw on the previous page showing where you could find that address. If you go to that location and they are unable to serve a registered agent at that location, this is where you would want to go next after you have that affidavit. When a business has been dissolved, you can request to serve through the Secretary of State's office from the get-go. If the business is active, you'll want to first attempt service through those traditional means, like serving the registered agent or other officer at the registered office. And if that fails, then requesting alias to issue and service to be allowed via the Secretary of State. So first, we want to establish that solid record showing diligent attempts at service through the traditional means, so that may require several attempts at an office or business location prior to requesting service through the Secretary of State. But then again, if the business is dissolved, you can go straight to the Secretary of State. And it's also worth noting here, dissolved businesses, not always great targets of serving process, but you can serve a dissolved business for up to 5 years after it dissolves. And we'll have to save that kind of issue for a future commercial collections presentation, because that's piercing the corporate veil and doing other things like that. That's something that we would need an entire hour at least to get through. So let's talk about partnerships. Just touching quickly on serving partnerships, a partnership may be served by leaving a copy of process with any partner personally or with an agent of the partnership found anywhere in the state. This statute basically states that partners are interchangeable, that you can basically, when you serve one partner of the partnership, you're basically serving any of the other partners that are listed as partners in the partnership. So this statute specifically allows substitute service and considers all partners to be interchangeable when effectuating service. As long as you also follow up. So if you are not serving the partner you're intending to serve, you just need to make sure if you serve via this substitute service, a different partner, that you're following up with the required mailing. So let's move on. So that kind of it is where I wanted to at least touch on the basics. We talked a bit about the statutes that we frequently use here at Weltman to serve commercial entities and individual defendants. Let's just talk about a couple of common service issues, and then we're going to open it up to some questions. And you guys can type in any questions if you have any time during this presentation. And we'll try to get to them. So going back to 2-203 service on individuals, I wanted to return to this in this section because often we see failed service affidavits with one attempt and process servers indicating they're unable to access an apartment building, a condo building, or gated residential communities. This is an issue in Chicago because we have a lot of apartment buildings down here and condominiums. Section 2-203 specifically addresses this issue, indicating that an employee of a gated residential community shall grant entry to the community, including its common areas and common elements, to a process server authorized under Section 2-202 of the Code who is attempting to serve process on a defendant or witness who resides within or is known to be within the community. As used in this section, gated residential community includes condominium associations, housing cooperatives, or a private community. So if there is a doorman, a concierge, a property manager, maintenance employee, an association employee controlling access, a server should first identify themselves as an authorized process server under 735 ILCS 5-202, display their process server credentials if they have them. If they're a licensed private investigator, they will want to show that to someone, to the person who is controlling access. They'll want to state that they are there to serve legal process on a specific resident known to live there. And they should also cite this statute here and request access only to the common areas for the purpose of attempting service. If a process server sees a building, this might be something that you want to look into prior to serving. You see that a building that you're trying to serve is going to have multiple units. So say you see apartment 506 on your summons. You'll want to try to look up that building prior to service and try to identify perhaps the management company before arriving. If after the first attempt the building is locked, process servers or the company that they are working for, they should do a bit of research, trying to find the building manager, property owner, what specific association might be in control of that building or management company, and attempt to resolve the issue prior to additional attempts. What isn't helpful, which we have seen before, is a return affidavit stating that the building is locked, or attempting 4 different times with the same result showing building locked, building locked, building locked. We also don't want to have process servers trying to quote unquote tailgate into buildings or try to sneak in or anything of that type. That is just not a good way to try to proceed. You should also consider, like we said earlier, sheriff's service is also available in certain circumstances. Sometimes people are a bit more open to opening a building to a sheriff or someone who is in uniform rather than a private detective who may kind of look like you and me on a normal day, and just kind of looks like someone that you may not want to let in. But generally allowing police into the building should be relatively safe. The next issue I wanted to discuss is evasive defendants, and basically the entire purpose of this webinar was to discuss evasive defendants. These create 2 separate issues: getting the papers that you want to get into the defendant's hand, get it in the right person's hands, and building a record that shows the court what happened. So The second part is why we wanted to do this webinar. An affidavit that simply says no contact is not a useful conclusion. We don't want conclusions in service affidavits. We want facts. Vehicle present in driveway, lights are on, sounds coming from inside the house, person looked through the window and didn't answer the door. These types of facts are much more useful to attorneys and to judges when determining whether or not someone lives at the location and whether the defendant, the targeted defendant, actually lives at that location as well. If someone opens the door and tells you that the person moved or doesn't live there anymore, but you have information that they do, it's not out of the realm of possibility that the person isn't being entirely forthcoming. That's why facts surrounding service are important. Conversations, noting what people told you, conversations with neighbors, observations, like we saw with the vehicles, the packages we saw on the front doorstep. We're not intruding, we're not touching packages, we're not opening mailboxes, we're not going into open garages, but we're trying to observe as much as we can and include those in the service affidavit. For attorneys, an evasive defendant can become an alternative service issue pretty quickly. But going back to this again, it's the quality of the service field notes from our process servers that will likely end up determining whether or not we can establish reasonable diligence later on. For process servers, you need to vary your attempts. You want to try different times, different days. 3 attempts on a weekday at 10 a.m. tells a judge very little. A weekday morning, an afternoon, an evening, and a weekend attempt can tell a much more complete story to the court. An affidavit that simply says no contact or no answer versus occupant of house observed me through the door window, refused to open door, said through the door, go away, things like this. Those are 2 very different affidavits that will be viewed very differently by the court. As attorneys, we're not simply counting attempts. Let me say that again. We're not simply counting how many times you tried. We're looking at the quality of those attempts and what the server actually documented. So I want to open it up to questions if we have any. It looks like we may have one here. How detailed should the description of the person served be to perfect service and survive a motion to quash? That's a good question. We will go back to that statute. So the statute doesn't say hair color, eye color, weight, things like that. But it does note that, we want to note the race and approximate age of the person that is being served. But if there's additional information that, the process server can observe, that is great information for identifying whether it was a family member or perhaps even the defendant themselves. Process servers, a lot of times they only see a name on a piece of paper, on the summons and the complaint. They don't know specifically what a defendant may look like. So we're going to want process servers to note as much detail as they can about the person who opens the door and the conversations they have with that person. And like you mentioned, surviving a motion to quash, that is why we need to be diligent in our attempts, and we need to keep those field notes. Those field notes are the most important thing for requesting service via alternative means, as well as defending service if a defense attorney or a defendant files a motion for special appearance in order to simply challenge our service, challenge our service. So, it's something that, we need to make sure that we are, like I said, not just counting attempts, we're looking at the quality of those attempts and the information that was documented at the time. So I hope that answers the question. It looks like I only had the one. Been going for a little while here, so if you have any other questions, feel free to email them to us. I just want to be sure to, oh, well, here's another question we can just note on. Someone had a voter registration information in the 2031 affidavits. I also recently had a 2031 motion in which I used affidavits from other pending suits against the same debtor. That's a good idea. These were not my process server attempts, but they are contemporaneous and supportive of my motion. That's really good. That's a good comment. If you do have that information available to you, that is really good for showing that other service has been accomplished. If those other lawsuits, if service was perfected in those cases, showing that, even though maybe our service affidavit would show that nobody answered, or we don't really have the information to show that the defendant lives there, perhaps attaching those to your failed service affidavit, showing that it was somewhat recently. That would be a very good information for the judge to see. Thank you for that comment. That is great, and I do want to encourage everyone to reach out. This is a topic that I deal with a lot sometimes, and so it's good to hear additional information or ideas that people may have for trying to show reasonable diligence, which is what judges are looking for. They want to see that we're actually looking into this and trying to make sure that we abide by due process and that we give every defendant notice and an opportunity to be heard. And that's what the essence of service is. It's providing a defendant with notice and an opportunity to be heard before the court. So just to wrap up, I want to let you know, ask you to follow us on our LinkedIn, Facebook, X, and TikTok pages. Just search Weltman in those search bars to find our pages. Also, be sure to keep an eye out for upcoming webinars in your email inbox and on social media. We hope to see you there, and we'd love to hear from you if you have additional questions or comments, or you want to learn more about Weltman's commercial or consumer collection solutions. So feel free to reach out to me or someone else from our team at any time. And this is my information. If you ever want to reach out, it's been fun. I appreciate everyone who's attended, and look forward to hearing from you sometime in the near future. Thank you.